Hello, welcome to Divorce in a Better Way and this episode of our educational webinar series. Today's series is going to be on divorce mediation, how it works, and why it provides you with a better way to go through your divorce. Just to give you a little context around the information you're going to receive, I am Susan Guthrie. I am a family law attorney and mediator. I've been in practice for almost 30 years. And I am the founder of Divorce in a Better Way, which is really intended to be a place where you can come to find innovations, tips, and expert advice on how to move through your divorce in a better way, in a way that is not the standard, default, difficult experience that I have been going through for almost 30 years with clients. So as a part of Divorce in a Better Way, I also have Connecticut Family Law Online and La Jolla Mediation. And through those, I do provide online divorce mediation services to clients in California and Connecticut. I am also the co-host with Rebecca Zung of Breaking Free, a modern divorce podcast, which is also focused on trying to bring you sort of the inside story from two top divorce litigators, our perceptions of divorce and transformation and the change that happens and how you can get through this period again to get to the other side and really break free from the difficult time that is that divorce process. I also do regularly contribute to several different industry publications, including Divorce Mag, Slitcom, A Corner, and Healthy Divorce Blog. So if you would like to see any of those articles or get more information, you can either Google those publications or just go to the website. And finally, I am an online dispute resolution expert. I both provide, as I said, online dispute resolution services, but I also train other professionals, including mediators and divorce attorneys, but other professionals as well, in how to integrate an online platform into their practice to give clients that ease and ability to work through their difficult issues, including those of divorce, in the privacy and comfort of their own home. So today, we have a few goals for today's webinar. The first is to give you some basic information about just what divorce is, and the mediation process as it applies to divorce. And as well, I'm going to discuss the benefits of choosing mediation over litigation for working through those issues of your divorce. So first, what is divorce? I know we all have a perception of that, but at its very legal core, divorce or dissolution of marriage, as it's called in some jurisdictions, is really a formal judicial process that takes place in order to terminate or end the legal status of the parties as a married couple. So when you got married, when you went through that ceremony, when you got that legal license to get married, you created a legal status that has with it certain rights and obligations that go along with the status. Now, some of those things are like the right to file your taxes as married filing jointly. You can't do that unless you're legally married. There are also obligations that go with being married, things like being responsible for the necessary expenses of your spouse in some cases. So if your spouse incurs medical expenses that they are unable to pay for, in some places or under some jurisdictional laws, the third-party creditor who provided those services would be able to come after the spouse for them. So as a result of being married, you create these marital issues that at the time of a divorce need to be resolved. And they fall into three broad categories that you see here on the screen. The first one is the property division, or the division of your marital estate. And that really comes down to dividing your assets, your marital assets, and your marital debt. So it's the good and the bad, the positive and the negative, but it must be determined who's responsible for what, who receives what, who gives what, who gets what. In addition, if you have minor children, there are going to need to be custodial orders put in place, as well as some sort of access schedule that's considered by the court to be in the best interest of your children. And finally, there will be issues going forward of support. So certainly in those cases where you have minor children, there's going to be child support. But in many cases, there can also be spousal support or alimony, depending on your jurisdiction. So those are the broad strokes of issues. There are many, many other things that flow from that. But what ends up happening in a divorce, or what you're facing if you're facing divorce, is you need to resolve all of these issues in order to get divorced. So the question becomes, how do you do that? So there's really only two ways to resolve your divorce issues. The first one is the most common, I'm happy to say, and that's that you do it by agreement. So I think it's a statistic along the lines of 95% of cases are resolved eventually by the parties coming to an agreement, meaning they agree in some fashion as to how they are going to handle all of those broad stroke issues that we just talked about, their property settlement, their child custody, and their support issues. For those cases, the other 5% that cannot come to an agreement, well, that's where you're going to have the judge making the decision. And those are the trial cases. Those are the ones where you go in, you put your case on, you sling your mud, you toss the dirt around, and the judge, the man in the robe in this picture or the woman in the robe, the judge in their discretion in many cases is going to make the decisions. They're going to tell you what you're going to get, what you're going to pay, what you're going to receive, when you're going to see your children, where they're going to live, what's in their best interests, and how much support you're going to get or pay. So that is, again, not really the norm. Most people come to an agreement, but then the question is, well, how did they get that agreement? How did they get to that point? And that's what we're going to focus on today. So the first way is the traditional litigation process. So even when parties lawyer up, which is what the traditional litigation process looks like most often, it's where both parties go out and get an attorney. The attorneys take them through this formal proceeding and take them through discovery and then the negotiation and hopefully, again, arriving at an agreement. It is the default model. Again, it's what everyone, I think, thinks of when they think I'm getting divorced. It is a formal proceeding. So you have an attorney. Your attorney is a professional. They are your legal counsel. They are also your representative, meaning they speak for you. You do not go into court, and unless you are under oath or testifying, you will not be speaking to the court. Your attorney does it for you. And everything moves through your attorney. So all of the correspondence, all of the paperwork, all of the requests for discovery, all of that just goes through this formal process, all done by your attorney. This is always available to you. So as the default, if you try some other method to come to agreement and can't do it, you always have the ability to fall back on this, but it does have some drawbacks. The first is it is an adversarial model, meaning, it is set up as a traditional lawsuit because it is a traditional lawsuit. It is plaintiff versus defendant. Again, you both have your attorneys represent you. You are one step removed from the process. Someone else is doing all of the negotiating for you. So even though you may move through that process, it's all handled by your attorney. They have certain steps they must follow as a competent practitioner to do what they need to do and represent you well. They have to check off all of the boxes. And they are doing all of that on your behalf, but of course they're going to be charging you for it. And they will hopefully eventually negotiate with the other attorney some sort of a settlement. But the whole process is based upon being coercive. So when I'm representing a client as their litigation attorney and my client wants to know about the finances of the other spouse, I send out a request for discovery and I list all of the documents and I cite the practice book section and I say, you must get these to me in accordance with the practice book in 30 days. And if they don't get them to me without the proper extension of time, I file a motion for sanctions. Everything is done in that very formalized fashion because it's very rule-based. It's in order for it to proceed smoothly, the attorneys have to follow down a certain pathway. Unfortunately, it feels very coercive. Nobody enjoys being told, you must get me this within a certain period of time. There's no, hey, it's practical that we exchange some information. Why don't you get me the paperwork? I'll get you the paperwork and we'll go forward sensibly. That is not really how a litigation action proceeds. Because of this, it is exceedingly time consuming. Time will get away from you very quickly because nothing happens quickly in a litigated case. And because it's very time consuming and your attorney is the one spending all of that time, it also is extremely expensive. And because it's coercive, it's divisive. So at a time when you're already going through difficulty, this is not an easy time, divorce, and as you're already going through a difficult time, this process is pulling you further and further apart. And the problem with that is if you have children or even just want to have an amicable relationship with your former spouse in the future, this divisive process is not really conducive to helping you do that. It's also setting up an institutionalized conflict cycle. So I thought this was brilliant. One of my colleagues used this phrase, and it's very, very true. What you are learning in a litigated case is that when you have an issue that needs to be resolved, you go to an attorney, and your attorney handles it for you. So while that may be in some ways comfortable, letting someone else do the hard work, it is hard work. It's going to be expensive. And then when you continue to have issues, because life is not static. Even though the divorce is finalized, it's not uncommon that there are things that need to be tweaked or changed in your parenting plan. Your children grow up, things change, financial situations can change, and there are oftentimes you need to rework or revisit some of the issues. And what you've learned in the litigation process is to go back to your attorney. So you just start the whole thing all over again. So the question now is, well, what can you do other than litigation? And that brings us to mediation. So that's providing you with an alternate method for resolving all of those issues that we talked about and staying out of the litigation track. So you exit the litigation track, you go to divorce mediation. It's an informal dispute resolution process. So I referred to litigation as a formal dispute resolution process. Mediation's informal. Instead of it taking place in a courtroom, it actually takes place either in a conference room with your mediator, or in my online cases, you might be sitting in your living room or your office or some private place. Your mediator will be in their office somewhere, and your spouse may be somewhere else. But this takes place in a much more comfortable setting, in a private setting, which is important. It's completely voluntary. So you are not compelled to be in mediation. You may be sent to some type of mediation by the court. Some courts have compulsory mediation on certain issues, but true divorce mediation, start to finish, you two choose that you're going to get off that litigation route. You're going to go to the mediation route to try to resolve your issues. In divorce mediation, unlike in litigation, you and your spouse are the only ones who make decisions. So people always think that the mediator, they go in and just like a judge, they tell the mediator what's going on, and the mediator is going to tell them what to do. That is not divorce mediation. Divorce mediation is where your mediator is going to support you and help you, but you two, the people going through this, whose lives are the ones that are impacted, will make all of the decisions. Because it is a voluntary process and takes place in a less formalized setting and is a less formal process, it is cost efficient. It costs infinitely less money than a litigation process. You are also only paying your mediator, and you're both paying the one mediator. Now, sometimes you will have outside counsel, but it's usually on an hourly basis, not the all-encompassing representation that you have in a litigation case. It's much less time consuming. You and your spouse will set up the timetable, but you are not waiting on a judge or court time availability to move things forward. You're not waiting for discovery to be done. You're not waiting for depositions to be taken. You're not waiting for things to happen that drag out your normal litigation case. It's private and confidential, as I referenced earlier. It's taking place either in the privacy of your home or office, or in your mediator's office. It's not in a courtroom. It's not in front of other people. It is in a place of your choosing. And mediation allows for what I call a team approach to provide you and your spouse with the best support to work through the process. So as a part of mediation, we will often bring in other professionals. I'm an attorney, so you have a legal professional in the room, and it is a legal process. So there's quite a bit of information about the law that you will need to process these issues. But sometimes there are other professionals that are helpful. So sometimes we will work with mental health professionals, marriage and family therapists. In other cases where we have complicated financial issues, we may bring in a certified divorce financial analyst. And that is very easily done in the mediation setting. Either they come into the conference room for a session, they may do work outside and provide it, or in the online setting, they may come in on a Zoom meeting with us all. But they are there to and available to the two of you to give you that information you need to make informed decisions. Because remember, again, you're making all the decisions. So there are really three phases of the mediation process. You're going to identify the issues. That's those three broad strokes I talked about in the beginning. You're going to discuss the issues, and that includes giving you a lot of information about it. And then you and your spouse will have the discussions to agree on those issues. And the agreement is really, as we said at the very beginning, the agreement is the end result of a good mediation or any process. 95% of the cases, they get to an agreement. Mediation can get you there. Step one is identifying your issues. I call it fact-finding. And this is really, for the most part, gathering and sharing your relevant financial information so you can quantify that marital estate, as well as there's some personal information, that you may need to provide. And that's really more for the pleadings and things like that. The next step, step two, is when you discuss your issues. So this is an important phase. This is probably the most important phase because there's a lot that goes on here. Your mediator's role in the mediation is not to act as your attorney. So although I may be an attorney in a mediation, I am not giving legal advice to my clients because I have two of them there. I can't give legal advice to one that would not perhaps affect the interests of the other one. So your mediator is there as a neutral to equally support the two of you and give you the information and the support that you need in order to make those decisions. And that support comes about in a lot of different ways. The first one is to educate you both on the law pertaining to your issues so that you have an understanding of what you're talking about, like what would happen in a courtroom or what might happen in our experience in the courtroom. What does the law say about this particular issue? Now, that's not to say you have to do that. In most cases, you can decide between you that it might be better to do something else, but you still need to know what the law provides. Your mediator is also going to make you aware of the sub-issues that flow from your major issues. So as an example, if you have a marital residence that you own jointly, there are a lot of issues that flow from that if one of you is going to keep it or if you're going to sell it. If you're going to sell it, well, how are you going to pick the agent? How are you going to pick the listing price? What's an acceptable offer? Who's going to pay for the maintenance until it sells? Are there going to be any fix-up costs? That sort of thing. So there's a lot of sub-issues there. If you're going to keep it, what happens to the mortgage? Who's going to pay it? Are both parties going to stay on it? How will title be held? Will it be sold in the future? There's a lot to talk about. Your mediator knows the issues. And so as you work through your decisions, your mediator can then make you aware of the additional things you need to talk about and decide. Your mediator is also there to facilitate your discussion. So always understand that this is a difficult process. No matter what method you use to work through these issues, they're hard things to talk about. And most often, I find that when two people try to sit down in the emotion of the moment and talk about these things with just the two of them together, this doesn't go well because the emotion comes up. And that's not to say that it doesn't come up in mediation, but your mediator there is a trained neutral to help you work through those moments and get your conversation around problem solving, getting to how the two of you can move forward, what you can live with and what you cannot live with in order to come to agreement. And to do that, your mediator is going to help you problem solve and they're going to help you brainstorm. So a lot of what goes on in mediation, especially when you have a mediator like me who's been doing this for so long, is a lot of the issues that are going to come up in your divorce, we will have seen before, and we will have seen clients that have addressed it in a variety of different ways. And so we can give you some of the ideas of what we have seen other people do. That may not be the right thing for you, but it might start the conversation or the thought process that will get you to the point of being able to come up with something that does work for the two of you. And finally, once we've moved through that discussion process, you come to an agreement. And that's really where you put all the puzzle pieces of your agreement together, because it's always important to understand that you cannot make decisions in a vacuum. So you cannot, in general, decide what's going to happen with one particular asset, say, without knowing what's going to be going on with the other issues that need to be resolved in your divorce. So as you're working through the issues of the divorce, we're also working to pull it all together in a cohesive whole. And when you get to that point where everything works together and the parties as and in its entirety believe that their agreement is complete, then you have come to the end of the process. At that point, in any divorce process, you need to put your agreement in writing. You need to have a written understanding between the two of you as to what your rights and responsibilities are with respect to how you're handling the marital issues. And that is what gets submitted to the court in your divorce proceeding that will become your divorce judgment. So this is a very important document. If you have a mediator who is an attorney, often they will be able to draft this for you. If you have a non-attorney mediator, then they usually will provide you with a memorandum of understanding or an MOU, and you would take that to an attorney to have the legal document drafted for the two of you. Now, I end with this picture not to be negative, but just to really emphasize that there is a truly important consideration in trying to work through your divorce in as amicable a fashion as possible. Because by being able to open these new pathways of communication in the mediation process, the hope is, and statistics show, that parties are able to go forward beyond the divorce mediation process and work together to work through whatever issues may arise, but often they are co-parenting issues. So for your children's best interest, the number one predictor of difficulty for children is the level of conflict between their parents. And that's not to say just conflict over children, but just any conflict. So when you come into mediation, it's the two of you sitting down and problem solving. And although that may seem that, it's an impossible dream, it happens in mediation because you need to work together, give and take, compromise, to come to agreement so that you can both move forward and your family can move forward. So if you'd like some more information, again, please feel free to visit my website, divorceinaBetterWay.com, or you can listen, you can listen to our podcast, Breaking Free, a modern divorce podcast, which you can find on iTunes. So thank you for joining me today. I hope you found this helpful. And if you have any questions, you can reach out through Divorce in a Better Way. My email is on there. Thank you.